An Obama judge in Georgia has rejected some key witnesses that are necessary in an election trial. The trial apparently is going to expose all of the problems in Georgia, but a little difficult to do if you don't have any witnesses. The judge that we're talking about is Amy Totenberg, and we've gone through an opinion of hers here previously that set this case for a trial. She had evidentiary hearings. This case has been going on for years, since 2018, I believe. And she said, look, we have to have a trial on this because what has been shown is that there are pervasive problems throughout Georgia. They changed their election systems. Brad Raffensberger, you know him, the Secretary of State, is saying everything's perfect. Most safe and secure election of all time. You remember all that garbage? Well, she posted an opinion. She said, look, we have to have a trial on this thing because it really is that bad. In Georgia, a lot of the election officials are freaking out because we got an election right around the corner. And what happens if the judge says, your systems are so bad that you got to do something about it? They're hitting the panic button. And so we're going to go through a couple filings. This proffer of evidence is explaining that witnesses are being precluded by the judge. Hard to prove your case if you don't have witnesses. But this is what Politico tells us. Election officials are really hitting the panic button in Georgia. We got an election coming up. It's a pretty big state. They say there's a recipe for violence. Atlanta District Judge Amy Totenberg, she's weighing whether she can issue an order from the bench to mandate additional protections in Georgia. So everyone's going to be fortifying their elections. And in 2020, when we were here, we covered a ton of election litigation. Oh my goodness, it was maddening. And we're going to see it start to really escalate as this cycle begins. Now, 5 years ago, this case has been going on for a long time. Amy Totenberg, the judge, won plaudits from U.S. election officials for forcing Georgia to ditch its voting machines. Okay, this is a long time ago. Now she's weighing a similar order. The prior machines were susceptible to hack. She said, get rid of them. Now they're asking her to do it again, but this time a slew of election officials are begging her, don't change the system. You understand why that is, obviously. Previously, they needed her to ditch its electronic voting machines and then install new ones that were, anti-Trump. Then if she fortifies the elections and they have to fix everything, those fixes maybe won't be anti-Trump. And so now they're saying, please don't change it. We like it how it is. It went blue last time. Current and former officials from both parties at local, state, and federal level, they argue that Georgia's current voting machines are far less prone to sabotage than their previous predecessors were, which didn't produce any paper record at all. But we remember here, we covered all of this. There was a QR code problem where you would go and you'd vote. You'd say Trump, 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 and then submit. They'd say, great, thank you for your vote. It'd print out a QR code. You could read Trump, 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 Trump. But in the QR code, when you scanned it, the computer saw Biden, 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 Biden. What the heck? And you couldn't tell because the QR code is something that we can't read. So they say they're very panicked. Now they say forcing changes to the November ballot is a recipe. Here is a recipe for unrest and potentially violence, said a lone Democrat on Georgia's election board. I don't know what that means. Is she threatening an insurrection for having a safe election, an integrous election? Now the civil trial that we're about to read from kicked off back on January 9th in Atlanta, expected to wrap on Wednesday. Now Totenberg, who's going to decide the case without a jury, is going to issue a ruling. And we saw today that there are not going to be some witnesses. They're marking their record for appeal, saying you denied our evidence. So that means public confidence in the 2024 election in a key swing state rests to an unusual degree on this one judge. What's she going to do? Now, and while fears of Russian election interference were high at the time back in 2000, her first ruling, now this time the stakes are much more concrete. The people and the technology at the heart of the court battle are now at the center of Trump's allegations about a stolen election. Now, Totenberg, an Obama-Appointee, as we saw, is known for her intensity. She went to Harvard. Gosh. And the arguments she first heard in the last few weeks are the latest twists in this case. And remember, Georgia purchased the Dominion voting machines for $100 million. Whew! Dominion sued a bunch of people. Now, they have drawn support in this litigation. Totenberg declined to be interviewed for the story. There were opening arguments on the first day of trial, and in the courtroom, she often leans the side of her head deep into her palm, her eyes barely peeking out at the witness. Now, she has not indicated that she would bar the state's current voting machines like she did in 2019, but she had said that the machines put the state at a real risk of a hack, right? She's admitting this, and has floated ordering reasonable fixes. Coalition says that Dominion remains ripe for abuse, and this is where the litigation is going now. Election officials say no. Paper printouts from Dominion machines can help spot tampering, and so there's no real risk. They say it's overblown. All right, so they are explaining what else is happening. So we get the background. Now let's jump into the actual. This is now plaintiff's notice of a proffer of evidence. All right, so plaintiff Ricardo Davis's first proffer of evidence. Same court, obviously, same case, Donna Curling versus Brad Raffensberger. Now this is something that came in very recently, January 30th. They say, all right, Your Honor, to Judge Amy Totenberg. They say, on November 14th, our client, Ricardo Davis, who's challenging your bad machines, filed for leave to amend amend the pretrial order, right? And a pretrial order is something that is going to dictate how the trial works, right? It's an order about how the process will be. And so you settle on it before the trial starts. So everybody knows how much time everybody has, what witnesses are coming, all the things. So they wanted to amend that, and they wanted to add 2 witnesses and a number of designations to the record at the upcoming trial. They're saying, oh, we're going to trial on this. Great. We need witnesses. Now, at the time when they filed this leave to amend, the pretrial order was not yet signed or entered into the clerk's record. So it was still open. Davis's basis, our client, was that he had not been given an opportunity for input into the joint proposal that came out from all of these people, right? So they settled on this joint proposal and they entered it. But our client didn't get any opportunity to be involved. So then we filed a motion to amend, and plaintiff, my client, made an oral proffer, so in court communicated this openly, that we have evidence about these witnesses and we want to call these witnesses when this trial happens. But something happened now, obviously. Plaintiff Davis now contends that as a result of the court's order, which denied them, didn't modify the pretrial order, so they couldn't call their witnesses, they say he was denied an opportunity to present his evidence. We got a trial here, and so we're going to be appealing this. Now, he's been waiting 6 years to get to this point, and as such, by rejecting his witnesses, Judge, you have substantially decreased his odds of success. And so we're going to make a record. They say now our client shows that this evidence was relevant and material to the issues that were going on at trial. And the big question was whether or not Dominion and their voting systems that were employed by the state of Georgia, whether or not it infringes on his rights under the Constitution to have his vote count. And so these claims are generally brought under the Equal Protection Clause. But the idea being, if your vote counts and my vote doesn't, then we are not equal under the law. Something has happened in our election laws that have disenfranchised me, or vice versa, disenfranchise you. So if we have equal protection of the law, everybody's votes count the same. And if we're treating all votes differently, that's violating the Constitution. So saying he has a right to pursue this. Now, as a result of Judge Totenberg and your order, our client is not allowed to talk about certain evidence at trial, including these bits. For example, they say that our client was prohibited from offering designated depositions into the record, one from Kathy Latham. Now, she is a key eyewitness whose deposition testimony supports our claims that the machines are bad. The intent of Mr. Davis was to include specific designated depositions, including her referenced affidavit that has eyewitness details of how the Coffee County Dominion system was accessed wirelessly, despite claims from the vendor and the defendants, right? Kind of an important witness who was accessing the stuff wirelessly. So our client, he contends that these designated depositions that are already identified in the docket, they would show the following things. If we could call this guy as a witness to show that your machines are bad, this person would show that during the 2021 Senate runoff, Kathy, the person, served as a voter review panelist who was actually in the computer room on election night. She was there with Misty Hampton and Ernestine Thompson Clark, who is a representative of the Democratic Party. Now, in addition to the absentee and the UCAVA ballots, there were approximately 6,000 advanced voting ballots from a field scanner that failed during early voting that required scanning after the polls closed. Now, as they began scanning these, and she's a witness there, the 6,000 advanced ballots on the Dominion ICC central scanner, the workstation computer displayed a QR code failure error message. Oh no! That rejected at least one ballot for every small batch, including batches of only 5 to 10 ballots. So a bunch of stuff got rejected. And remember, in Georgia, I believe the margin was about 11,000. So the QR code failure error only occurred on ballots that were cast for 3 Republicans. Oh, that's weird. How'd that happen? Republicans David Perdue, Kelly Loeffler, and Bubba McDonald. All their ballots got rejected. Wonder what happened. Dominion technician, this guy called Samuel from Colorado, was an extra technician assigned to the county after recount failures occurred in the other elections. What happened with the recount failures in June 2020 primaries and November, the 2020 election? Wild. Now, the technician just came out and said, oh, just wipe the scanner down, all right? Just blowing it. Blow some canned air in there in the eye of the scanner. Blow. Well, guess what? That didn't help. It's like your old Nintendo games. Hey, just smack the TV on the side. Maybe the antennas will work. So Eric Cheney then ordered Mr. Chalandris to get his boss on the phone. He said, why is this rejecting all of our Republican ballots? Hello, get your boss. So then they called Dominion, this guy, Scott Tucker. And he says, why don't you step outside the room there before you... They had a private conversation outside the room. He comes back 30 minutes later. It's like, the machines are fine. Okay, they're just fine. Just tell them they're fine. Blowing it. Tell them to blow harder. You have more canned air? Go to Best Buy. Go get some more. Mr. Chalandris walked back into the computer room, stood next to the scanner holding his cell phone, and then he told Misty Hampton to try one more time. Well, literally, that's what happened. Try it again. Turn it off and turn it on again. She was able to run the remaining batches of ballot with no problem, although no Dominion technician touched the voting system. Stood next to the scanner holding his cell phone, and then it fixed it. I guess that's the implication there, right? Stood next to the scanner, held his cell phone, and said, try it again. Then she ran it and it worked, but no one touched the machine. So I don't know. Did they want two options? One, the can of air work and it just worked, or there's more to the story. So anyways, here's the affidavit that they want into the record. So the next person they want to talk about is Misty Hampton. Now, plaintiff was also prohibited from tending certain designated depositions into the record. Misty Hampton, a key eyewitness whose deposition testimony is supportive of Mr. Davis's claims. They say he was going to call her Misty Hampton because this was a designated deposition. She has eyewitness details of how Coffee County Dominion system was accessed wirelessly. Again, despite their claims. Now, these designated depositions, they're pointing this out like we've already done these depos. Okay, they're already supposed to be here. This is already set for trial and they're already in the scope of this. So we want to show from Misty Hampton, and by the way, the judge rejected all these people, so they're not going to testify, or rather these depos are not going to be included as part of the record, apparently. But here's what she would have said. The Coffee County ICC mail-in ballot server was having severe ballot rejection problems back in January 2021 during the Senate runoff. The on-site Dominion technicians, one of whom is believed to be Gary Gaines, could not correct the ballot rejection problem. The technicians were pressured by the Coffee County election board member, this guy named Eric Cheney, to resolve the ballot rejection problem promptly. Fix it now. The two technicians went outside for 20 to 30 minutes, and one of them told her, try scanning the ballots one more time while holding a phone about 3 feet from the scanner. That's weird. They're just like, hey, just here, put it next to it. It's going to transmit a code or something. Now, the ballot scanning problem was then resolved and the scanners worked perfectly without either Dominion technician touching any of the equipment. What the heck? You know, technology is weird. Sometimes it's like if you like touch it over here, it just starts working again or something, but they're not even touching it. It's just a cell phone. Maybe the machines are talking to each other. Weird. So they want to get her records in. Judge said no. Another person, this guy called Jeffrey Lenberg. They say our client was not allowed to call another previously deposed witness. Now, this is a key fact witness as well. They say the intent of this witness was to ask him about details about wireless access about Dominion. Again, 2021 runoff. If questioned for an hour or less on the serious security vulnerabilities about Dominion, right? We just need an hour or less. Don't even need a lot of time. This is what he would have been able to confirm at a minimum through his testimony. This guy, Jeffrey Lenberg, he would have said, if he testified, first of all, he said, I'm a retired testing person for nation state vulnerability. Wow. I got over 30 years of experience at Sandia National Laboratories. Would have been nice to hear from him. Now, he came to Coffee County for several days to determine why the scanner was rejecting ballots back in 2021 during the Senate race. He identified that network connectivity between the scanner and the election management server allows the scanner to be remotely configured. Oh, that's why the witnesses were saying that they could just hold their cell phones up. Oh, now he determined that adjustments in scanner settings can cause ballots to be rejected, or they can correct a ballot rejection problem. He instructed Misty Hampton, previously seen, to run a series of tests on the scanner without him touching any of the equipment. And then he determined the exact scanner setting that Dominion changed remotely to correct a ballot rejection problem occurring on the evening of 2021. So they just fix it remotely. They said we can't do that. So he determined that once the setting was changed, he could replicate the problem that we experienced back in 2021. He also found that the scanner setting value that would reject the ballots cast for Republicans at a 6-to-1 ratio over ballots cast for the Democrats. So we know how these scanners work. We did a lot of this election litigation stuff, but basically, you know, they feed it a form, right? They feed it a template like this and they program it. So they say, okay, this box is this. Okay, so this box is, you know, Trump. This box is Biden. And then they print the template out. Then they have to show, you know, program the scanner. So the scanner images this, and then they have to say, okay, if you see a mark like in this location, Mr. Scanner, Mr. Computer Scanner guy, software, then if you see something in this region, then count that for Trump. If you see something in this region, boop, 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 boop over here, then count that one for Biden, right? They say, you know, if you see a mark over here, then that means that they signed it or whatever. So they have to match it. Then when the scanners come through, it just, oh, boom, 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 right? Counts it all. So what they have done, it sounds like, is maybe, you know, shrunken this margin or something. If it's a Trump thing, it just gets rejected. So that is off. And it's specifically for Republicans. It's not happening for Democrats. Weird. Now, here's another person who they are apparently not allowed to talk about at this trial. He was not allowed to call another previously deposed witness called Ben Cotton. Now, the intent of Cotton was to ask him about extensive vulnerabilities vulnerabilities in the Dominion voting system that was used in both elections, 2020 and 2021, and the wireless access that occurred in 2021. Now, if questioned for an hour or less, this is what this guy would have said. One, that the server installation includes uncertified software that can be used for database manipulation. Great, nice. And the server received no updates for antivirus protection since the installation, whenever the heck that was. Also, the operating system received no updates since its original installation. And we're going to come back to this because what we're going to read in the next filing is that Dominion just said, well, we just updated our software. Just go update your app. It's all fine. Just update it. And they're going to say they can't even talk about that because none of that was included in the prior disclosures leading up to trial. So they say hundreds of program files were updated after the installation was complete. By whom, for what? The installation activates the wireless profiles for the Dell server chipset. Oh, so they actually have wireless chips in there, obviously, and they're activated. And if you install it, it activates the profiles. It also activates the wireless drivers, so it's actually doing stuff with it. And the installation also allows a wireless router to be added to the server network. Wireless cards and wireless devices exist within the server network, and the firewall rules allow remote access from any IP address in the world. Wow, that's pretty cool. Wow, how fancy. Now, the election management server is installed to be visible from a remote phone or computer. And the default port is detectable wirelessly from a remote phone or computer. Now, election databases are configured to allow it to be remotely accessed, the databases, and election databases are visible from a remote wireless device. Also, tabulation databases are also visible via remote devices, and a wireless device can be connected to the election database. SQL commands can also be executed against the tabulation or an election database from a remote device, and audit logs confirm that the QR code error that rejected ballots in 2021 was resolved at roughly the same time the eyewitnesses personnel resolved the error without touching the system. So they made some remote codes. Now, we want to submit all this as evidence, and we have been denied that. And so we make this proffer in good faith to preserve our client's rights in the event of an appeal, which maybe will happen. We'll see. So signed by David Olace there in Georgia. And that's very curious. You know, a lot of vulnerabilities there and a lot of people who we would like to hear from, who we think could add value to the conversation about who may or may not have been manipulating the data wirelessly and then magically just updating the scanner settings and everything through the cell phone. Pretty incredible. Now, it's amazing that Fox News settled that claim for like $800 billion when all this is still ongoing, but that's Fox. Now, here's another filing that came in prior to the trial. And I wanted to share this so we could see what they are explaining is happening here. What Dominion is trying to do is to just say, just update your software, and that's going to solve everything. But they are saying we need to exclude that evidence. Okay, it's not even relevant to the claim. They say Dominion now has 5.17. So here they are moving to exclude this. They say Dominion and Brad Raffensberger, I mean, Brad Raffensberger really, you know, as an analog of Dominion, defending the systems. They say they want to introduce evidence about their efforts to adopt a new version of Dominion. And they say, oh, this new version is going to mitigate our vulnerabilities. Because this guy called Dr. Halderman, he identified problems and CISA even validated them. Now they say that's okay. Even though it's like problematic, it's new software. They say, no, you can't talk about this in this trial. Why? Well, because you never provided any discovery about version 5.17, even though we asked you for it many times. Now, if you intend to introduce evidence about 5.17 as part of your defense, you needed to disclose that to us so that we and our experts could actually evaluate whether it actually does mitigate the serious security vulnerabilities that you guys are using. But obviously they didn't want to disclose it because it probably is still filled with holes. In other words, they just say, no, it's been fixed. We say, okay, let us see it. And they say, well, we're not going to give it to you in our discovery. They say plaintiffs' experts would also need to examine whether 5.17 introduces any new vulnerabilities that could be just as bad or even worse than the ones they identified in the current version. And we are entitled to take discovery into the costs and the burdens of upgrading this software in the beginning. And it's likely far greater than the relief that we're seeking in this case. Now, defendants, their failure to give us this version 5.17 was not substantially justified at all. Your Honor, if you let them introduce this at trial, it's going to prejudice us. Now, that is precisely ambush at trial that we do not want to see. Now, further, their supposed efforts to implement 5.17 there in Georgia is irrelevant anyways. We're seeking relief for the 2024 elections. They want to fix 2024, but the state has made clear, including in this trial, that the state will not adopt 5.17 in time for 2024 anyways. And so they should be rejected from being able to talk about it since they didn't give us it in discovery. Now, here's some background. On July 9th, the curling plaintiffs, the people who are suing to fix these problems, submitted requests for discovery. Now, with Within these, we wanted any contemplated plans to replace Georgia's systems. They objected, and of course, as a result, we did not get documents related to 5.17. But all these documents are responsive to us. How do we know this? This guy called Michael Burns, he went to the state election board meeting in Georgia, and he explained the difference. He said 5.17 is not even that big of a deal. When he showed up there, he said, quote, "It's not really an upgrade." He explained, "It will require us to fully rebuild the system." Wow. And that means the election management systems have to be completely rebuilt. What? So it's like a total overhaul. It is not an upgrade, 5.17. It differs from 5.5a. Okay, they currently use 5.5a. So 5.17 doesn't even sound like it's sequential. You know, it's not 5.6 or something. 5.17, it's maybe a whole different framework, which is really strange because, as we knew, in 2020, it was the most safe and secure election that America had ever seen. So why do they need to rebuild the entire system if it's so great? You know what I mean? Weird. Like, you don't scrap something that's working amazingly well. So he explained that an additional amount of hardware also has got to be procured for the county use. We can't even use that old crap machines that we were using anyways. So with respect to all the equipment, he explained that the transition to 5.17 will require not just a simple install and update, but it will need to be broken down all the way back to the BIOS level, which is like the chip software. You know, when you turn your computer on and you see that like screen like Dell or Acer or whatever it is, like that's the root base. Then that boots up the the operating system. So they're not just, you know, it's not surface level stuff. They got to go down and fix the basic operating system at the root, which is weird because I thought it was perfect. I thought everything was above board. So anyways, later in July, the plaintiffs, they then served their third set of demands saying, "Hey, can you please give us what we want? We want to know about security vulnerabilities." Why? Dr. J. Alex Halderman, who we talked about here, you know, he is a security expert, and he said, there are a lot of vulnerabilities here. So then they responded to the request. It was designated attorney's eyes only, and they do not have knowledge to the security vulnerabilities that were identified in his report. So they're basically, we don't have what you want. Now, subsequently, as we neared the close of fact discovery, the curling plaintiffs emailed Raffensberger, and they said, "What's your plan to give us this discovery? You've neglected to give us what we've asked for currently." And they replied that we'll review the pending requests and we'll see if there's anything to supplement. Sounds like Fannie Willis's office, my goodness. Now, defendants did not supplement their response at all. They didn't add any information about 5.17. They didn't tell us at all whether any vulnerabilities identified by Dr. Halderman were mitigated or not. So at no time did they supplement their responses or give us anything about 5.17. And so therefore, any evidence that's related to this should be excluded at trial. They did not produce these documents. They did not give it to us in discovery. They failed to supplement this. They didn't talk about any other mitigation efforts. They have not given us any justification for these failures. And if you introduce this, it's going to prejudice our case. Federal rules say they have to do this. Here, they failed to meet the rules. We served our discovery request. They knew about it on time. And we affirmatively requested that they supplement this more than 15 months ago. And now they're trying to dump this on us right at trial. They waited until trial to introduce this evidence. They had years to amend these responses, but they didn't. They failed to produce any documents. They had access to our report for over 2.5 years, and they just dumped it in here. Now, they attempted to explain this. They said, "Your Honor, in terms of things that were not produced during discovery ended as to everything but Coffee County last year, and I don't think it's fair for the state to be judged what it was doing in some cases a year or two ago when we're talking about current threats now." And so the state does move on, and these things have to be able to be provided for them as a fact finder. You know, it's like, but we really need it though, Your Honor. Now, it fails to acknowledge that discovery was ongoing. They have to continue to supplement that, and they failed to do that. So their failure is prejudicial. It's not like they really need it. They're not doing this out of good faith. It's not like, oops, we just forgot. This is prejudicial, and it's intentional. They did it. They flouted the discovery process, and they deprived us of an opportunity to test their claims because they knew if we tested it, we'd obliterate it. That's why they drop it. But Judge, we're trying. Now, as officials of Raffensberger's office have made clear, 5.17 is a fundamentally new version of the software. It doesn't fix anything. Michael Barnes stated that, quote, "It will require not just a simple install and update, but we're going to go all the way back down to the BIOS." Defendants have not identified what, if any, vulnerabilities they've addressed that it actually fixes, and they have no expert that they can even bring in to adequately address any of this during trial. And further, additional discovery would almost certainly establish we would find new and dangerous vulnerabilities within this new stuff. So given that the state's last software upgrade that was supposed to fix things, given the fact that it introduced new vulnerabilities, as well as there's an overall lack of sophistication and an accountability within their election officials, okay, so not only do you have equipment problems, you have software problems, you have implementation problems, like who's implementing the things, and you got like personnel problems. And then once everything's working, you've got to, like technically working, then you actually have to process the ballots, and then you got problems there. Everything is problematic here. And when you just said, well, just update your apps, that introduced literally even more problems. So we are skeptical that any additional upgrades would be free from problems. Time and time again, the state has demonstrated they are unable to implement sound election software. We've already seen this going all the way back to the DRE system and the Democracy Suite version 5.5a. So they say, in addition, we should be able to be entitled to take discovery into the cost and the burdens of upgrading the voting machines, right? We've got a short time now between now and November, and we got to fix all 159 counties. We don't want to do that. Defendants have argued in favor of keeping the current system, and they oppose changes that we want to be made here. Now, plaintiffs must therefore be able to take this discovery and show that the relief that they're seeking, and I think they want, more paper ballots, they want less machine counting. They say our version is going to cost far less than the cost of upgrading to 5.17, reinstalling all the BIOS and all the drivers and all the things. So our request is far less burdensome to administer the next election. We're just going to count the ballots by hand. That's fine, no problem. Just look at the paper ballots. That's easy to do. Now, version 5.17 is unlikely to be the last major software update. They're going to have 5.18, 5.19. As long as the state uses BMDs, the equipment, the software and the devices will have to be continuously upgraded, creating massive costs, logistical burdens that are going to be a lot more expensive than what we want. Now, you, Judge, recently ruled that the defendants were not permitted to introduce 7 untimely witnesses, one of whom is this guy called Nick Ikonakimakis. Now, he was slated to discuss version 5.17, so the judge also booted some of their witnesses as well. But in your ruling, Your Honor, the court said that Raffensberger's people did not demonstrate how their failure to timely introduce these witnesses was justified. Same thing here. The subject of his testimony would prejudice us. And the same thing is happening here. They have not explained how their failure to supplement their disclosures, why it was justified, why it was harmless. And so therefore, they should be precluded from introducing it. Now they say, similarly, version 5.17 is not going to be implemented before 2024, so we shouldn't be talking about it here. Throughout their case, we've argued that our relief is for the court to stop the use of the BMD system prior to the election cycle. Just stop them from using it, and we can count them by hand. We'll figure it out. Meanwhile, the state has made clear that 5.17 will not be implemented. So under the federal rules of evidence, we're not asking for an upgrade here. We're asking for basically enjoinment, right? An injunction to stop them from using the systems. And so it's not even relevant. We are seeking an injunction against the use of the BMD system. Particularly, we want an injunction prior to the 2024 election cycle, lest they risk further disenfranchisement. And Georgia has made clear 5.17 will not be implemented in 2024. How do we know? Charlene McGowan, she's legal counsel for Brad's office, stated that implementing version 5.17 would require the state to physically touch every single piece of election equipment, and that Georgia has 40,000 pieces of equipment that we must go in and physically touch and install 5.17 on each piece of equipment. She further commented, installing 5.17 before 2024 would be a rushed process. Yeah, I'm sure. And so vague statements like the above emphasize Georgia has no immediate plans to implement any of this, and so it's wholly irrelevant to anything we're talking about here. Now, in conclusion, they say defendants did not, Brad and Raffensberger, they did not supplement their discovery responses. They did not explain how they mitigated any of the vulnerabilities that we've identified, and their failure to supplement this is prejudicial. They dropped it all on us right as trial started. So evidence pertaining to all of this is irrelevant. They're not even going to use it in 2024, and we're asking for 2024, so this is of no consequence. Exclusion is necessary to prevent prejudice to the plaintiffs, and so keep it out, Your Honor. And so, very good stuff. I'm very grateful that we've got these attorneys who are fighting in this arena, because we don't have much of it happening out there, my friends. So ultra shout outs to David Cross, attorney, Halsey G. Knapp. They're both there in Georgia. He's pro hoc vice. He's coming in from Washington, D.C., from Morrison and Forrester, Crevelon and Horst, doing good work here. Christian G. Andrew Von Yu, also coming in from San Francisco, and some other really great attorneys here. So good stuff. And we'll see what Judge Amy Totenberg does, but we can see there's a lot of questions here about how this equipment works there in Georgia. And Brad Raffensberger has been the one saying everything's perfect, everything's fine, there's no vulnerabilities at all, most safe and secure election of all time. You know, all the garbage that we heard. Obviously, it's not true. And so we're going to be here. We'll see what Amy Totenberg says in her official order when she issues a decision. And so I hope you join us as we cover this. There's going to be a lot of election litigation that starts to pop off here, especially after some of these primaries are over, after Super Tuesday is over. We're going to watch it and cover it. So thank you for joining us as we do, my friends, wherever it is you're watching this. Thanks for hitting the subscribe button and that like button, and we'll look forward to seeing you back here on the next one.